Is the $250,000 cap on pain and suffering damages in medical malpractice lawsuits unduly harsh on children, the elderly, and stay-at-home moms? Listen to Wade Westhoff, whose 21-month-old daughter died in surgery, describe the current situation.
We didn't realize there was something called MICRA until about the fifth or sixth attorney that we had talked to declined to take our case. Our daughter was 21 months old. She didn't earn the income, so her life was deemed to have no economic value. And then since the pain and suffering cap was only $250,000, we learned very quickly that it costs $150,000 to put on a case, that personal injury attorneys or, advocates for victims harmed by the medical complex can't give advocacy or representation.
Bradley Corsiglia, a top medical malpractice lawyer, continues this theme.
So what it essentially has done, that 250 cap, has closed the courthouse doors to a lot of meritorious victims of malpractice.
Bob Pack describes how it doesn't make economic sense to pursue many cases.
When you go to an attorney, the attorney says, look, a child is only worth $250,000 in California because of this cap. It's going to take $200,000 to $300,000, could take $400,000 to go to a trial.
Claire McCormick describes how such a system provides little incentive for improving health care.
No one is punished. There's no accountability. No one's given training, to prevent these types of things happening again. And the hospitals don't have an incentive to make the economic investment in the resources that would help to prevent these things. Essentially what it does, the cap is discriminatory. A family of a child who's killed by a preventable medical mistake has no access to the court system. And without access to the court system, you don't have leverage to get accountability. You don't have leverage to facilitate change.
This is Mary Ann Toman-Miller reporting for the Peninsula Press, a project of the Stanford Graduate Program in Journalism.